the principles of constitutional law for W200. This is a taster for what you'll be looking at in W201, but there are three key areas that you need to concentrate on in your reading. The first is the doctrine of separation of powers. It's an idea that goes back to ancient Greek times. It's a way of analysing government. The ancient Greeks in their wisdom looked at government and said there are three separate functions of government. One is to make the law, and that's done sometimes by a separate institution called the legislature, but government requires lawmaking. There's carrying out the law, the executive function, and there's judging on the meaning of the law and the application of the law, which is left to the judiciary. And various systems institutionalise that or not. The American system is very institutionalised. If you look at the American Constitution, you'll see that the articles talk about legislative power resting with the Congress, executive power with the President, and judicial power with the judiciary. In the European Union, it's not as clear-cut. You can certainly analyse it in terms of who does what, but the legislative power is actually jointly carried out by the European Parliament and the Council of Ministers. The Commission is much more like a traditional executive, and the judicial power, obviously there is the European Court of Justice. What Locke and Montesquieu do in the 17th century is to take this a step further. What they do is point out that where those powers are concentrated in the same people's hands, tyranny is, well, they put it, inevitably will follow. And Montesquieu, of course, was writing at the time of the absolute French monarchs, and he looked to Britain. And he saw a system where the king couldn't get his way. He may have been titular head of the executive, but he has to deal with sometimes a quite independent parliament. And certainly the judiciary were independent. And Montesquieu said, here we are in France, we've got the king. One of them who even said, the state, that's me. That's going to lead to tyranny. Whereas England, because those powers are in different hands, liberty can flourish. And when the Americans set up their system, they go for a very institutionalised system. And you can't be a member of one and another one as well. So when John Kerry was a senator, obviously he sat in Congress, but when he was appointed Secretary of State, he had to give up his seat in the Senate in order to be a member of the executive. Have a look at the separation of powers as it applies in the UK. You'll see where it is observed, and the House of Commons Disqualification Act of 1975 and the Constitutional Reform Act of 2005 do make it clear that certain people, the judiciary, lower judiciary in the House of Commons, and in the Constitutional Reform Act, the Supreme Court, again, excluded while they are serving from the House of Lords. But central to the British system is this concept of ministerial responsibility, that the head people in the executive should be members either of the House of Commons or the House of Lords and are accountable to them. So it's not just some little accident, this is central to our system. But the lower levels of the executive are excluded. Have a look at the House of Commons Disqualification Act. So be able to describe where the overlap is and why it's there, and the other attempts to keep it as separate as is possible. The second key area is parliamentary sovereignty. Quite a bit of reading you can do on this subject, but very useful guide is given to us by a writer called Dicey, who you'll come to know and, well, perhaps love over the next couple of years. Dicey summarised parliamentary sovereignty into three key ideas. One, it was the idea that Parliament could pass any law it wants. He was contrasting that with the situation in the United States, where Congress cannot pass laws on certain issues. The Constitution says so, and should they breach the Constitution, you're then going to see the Supreme Court come and say that's unconstitutional, you cannot do it. That's not possible in the British system. Another comparison would be the French system. Again, separation of powers is part of the Constitution, and powers that are given to the French Parliament, if it's not in those powers, they can't do it. But the British system, Parliament can pass any law it wants. There's no circumstance in which you can go before an English court and say, Parliament doesn't have the power to do it. That's the first meaning. The second meaning is that no Parliament is bound by its predecessors, or, looking at it another way, no Parliament can bind its successors. So the kind of entrenched provisions that you'll find in the French, the American systems, will have no effect in the British system. You can't decide that British Parliament can't say, right, we're making this reform and it can only be changed if there's a referendum or if there's a special majority in the House of Commons, whether it be small, just 50% of all members, or the 3/4 or 2/3 proportions which other countries use. An ordinary Act of Parliament is sufficient to change it, and entrenched provisions will not bind a future Parliament. The third meaning was that no court can question what Parliament has done. It comes from the Bill of Rights, but again, it makes it clear that Parliament is the ultimate sovereign. The third area to look at is conventions, one of the sources of law. Our Constitution doesn't have a single constitutional document. It has the constitutional rules in a number of places. You'll find it in statutes, in case law, but conventions are quite important. And these are defined as non-legally binding rules, but which are regarded as binding by the political actors. So if the Queen were to use her royal prerogative power to refuse to sign a bill that had been passed by both Houses of Commons, she couldn't be challenged. She does actually have that right. But it's not one that is enforceable in law. But yet if you were to ask her could she do it, she'd say, oh, absolutely not. There's been a convention for now 300 years that the monarch always gives royal assent, despite whatever he or she may think about it. Why are these observed? Well, that's worth thinking about. I put forward as a suggestion that it's that the costs of breaking the convention are actually greater than any short-term benefit. So yes, the Queen could say, I don't like this bill and I'm refusing to sign it. But it will put her in the way of political controversy, and suddenly the happy monarchy that we live in now will become divided, and people will say, well, why should she have a say? Why should she be able to overrule the democratic parliament? So the costs are greater than the benefits. Same applies to some of the principles of ministerial responsibility. So that definition is quite important. Anyway, enjoy looking at UK constitutional law and the other tasters that you're getting for human rights, for criminal law, you'll find on the first of the key point videos that I've done for tutorial 3. Thank you.